with people arriving, maybe a couple more people to come in. I'm very pleased to welcome you all to the second of our two-part series on the Renters' Rights Bill. As you will all be aware, the bill promises to bring in some of the biggest changes in housing law in many decades. It's no exaggeration to say. It looks to be in its more or less final form, entering the final stages of passage through Parliament, and I understand that it's returning to the Lords in just under 2 weeks. So we should hopefully be on the brink of a new era in housing law. Last time, for those of you who weren't here, the speakers looked at the changes in relation to the period before and during the tenancy. This evening, we're moving on to consider the end of the tenancy, or not, if some of you have anything to do with it, with talks on the grounds for possession from Marie Paris to my right and Dominic Preston to my far left. As the filling for the possession sandwich tonight, Cara's going to be having a look at the provisions in relation to the enforcement of landlord legislation. And then finally, although she's not arrived yet, but I'm assured she's on her way, we are delighted to have Siobhan McGrath, the president of the First-tier Tribunal Property Chamber, joining us to talk about the role of the tribunal under the provisions of the Act. And then afterwards, I'm told to tell you at the outset, there will be refreshments served outside if anyone's worried about that already. So we look forward to joining you for a drink and catching up. So to begin with, Marie Paris, a colleague in the housing team in Chambers, she's recognised by the directories as a rising star of the housing law world. She's got a wealth of experience in the field. Prior to pupillage here, which is actually a few years ago now, she spent 2 years working at South West London Law Centre, and as the Legal 500 has it, she marries tenacity with a passionate belief in social justice. And despite the views you may have on directories, I think it's fair to say that they got that one right. Rather than embarrass her by reading out any more quotes from directories, which could keep us here for a while, I'm going to hand straight over to Marie to talk about some of the key changes to the grounds for possession set out by the bill.
Right, thanks, everybody. Ooh. Is that better? Can people hear me? Cool. Thank you very much, Dan. Yeah, those directories are just there so you can get introduced at seminars, I think. But there we go. So I'm going to talk quickly about the changes to possession proceedings right at the start. And then in a bit more detail, talking about the grounds that I think are probably the most likely to come up in the new world of possession. Though I will say, headline is, not much is going to change in terms of the proceedings. The changes are that there's going to be new grounds that I'll go through. So those are in Schedule 1 of the Renters' Rights Soon-to-be Act. There's going to be amendments to existing grounds. So I think most importantly, we're going to be looking at ground 8 and how that's going to change. There's amendments to notice periods that I will provide for you, but I don't expect you to memorize. I certainly haven't memorized them. And then there's penalties for breach of various parts of the new Act that might affect your ability to gain possession. So they're useful to know. Otherwise, the proceedings, I think, are going to be pretty much the same as the normal Part 55 proceedings. So I suppose when we get the new Act in place, time will tell whether they make a change to the CPR, but I think it's probably going to be about the same. Notices of seeking possession are still going to be governed by Section 8. All the new Act suggests they're going to do is that they're going to give the Secretary of State power to publish probably a new prescribed form. Well, certainly a new prescribed form, but we don't know what that looks like yet. I'm sure it'll look pretty much the same. But obviously, gone is Section 21, which we learned about last year. So all of these things, you have to make out a ground. In order to get possession, you have to make out a ground. But not all of the grounds are the fault of the tenant. So onto the really fun, dry stuff. Notice periods. So I've done a little table, which is a summary of the new notice periods for mandatory grounds, and then the next slide will be about discretionary grounds. As I say, I don't expect you to to really dig into this yet, but obviously it's going to be very important when you're on the duty scheme and thereafter to work out whether the notice was correct, especially for the mandatory grounds. No surprises, 7A is still an immediate one, so if you're committing serious crimes, you're not entitled to too much notice. 4 and 7B, we'll talk about what all these grounds are later. They're 2 weeks, but for our purposes, the notice period for ground 8, which I haven't, it's 4 weeks instead of 2 weeks, so it's doubled. So that's probably the most important one. But you'll have the slides later, so I won't go through every single one. Nothing is too exciting, I think, except for the newer grounds tend to be the ones that have 4 months notice period. So it's meant to, I think it's meant to almost mimic the Section 21 proceedings in terms of giving you that bit of extra time, but it's even longer. The discretionary grounds are over on the other slide. Again, unsurprisingly, antisocial behaviour ground is immediate. Checking it's the same one behind me. 10 and 11 is 4 weeks instead of 2 weeks. So those are the ones that we commonly see. 12, 13, I've put in 14, which is wrong. So 14 is immediate, but 14.7a is 2 weeks. But otherwise, it's not drastically different. It's just, it tends to extend the time rather than reduce it, which is surprising because when the RRB was being debated and certainly being promoted, especially to landlord, like the residential landlord people association, it was suggested that, oh, don't worry, Section 21 is going, but we're going to put in these really new strong grounds and make it harder. I think looking at it, it looks like it's not as drastic. The grounds aren't as horrible as we thought they'd be. So before we get to the actual grounds themselves, this is an important thing to note. So I've given you the actual law there, but the point is Section 7 is going to be amended of the old Housing Act 88. It's going to be amended to say that if you are in breach of Section 83 sub 3 sub A of the new Act, which basically means that you need to be have a sort of active entry on the landlord database, and it has to be, it can't just be you landlord have a license, but the property is not licensed. It needs to be you have to have an active entry as a landlord, and you have to have an active entry in respect of that property. If you don't, you're not going to get a possession order unless you can make out ASB. So that's really important. That applies to every ground except for ASB. I will caveat that a bit to say that they've retained a little bit of power for the Secretary of State to basically make regulations to change. The wording is either people who will be affected or circumstances where you wouldn't get a possession order. So I think it's actually pretty broad. So they might just be trialing out to see how badly it affects the ability to get a possession order. But at the moment, the way that the Act looks, or the bill at the minute looks, it looks pretty serious. If you're not on the database, you're not going to get a possession order unless your tenant is doing antisocial behaviour. So now on to the very fun stuff, the grounds. I warn you, it's a little dry, but you're going to need to know what these grounds are. So I'll run through them very briefly. You'll have the full, the sort of relevant parts of the grounds in the slides, but it's helpful to think about what sort of defences we might be able to run. So last week, if you guys were here, David Cowan in particular was talking about how it might be so difficult to get possession on these grounds now because it's going to be quite often, I think, that the test under CPR 55.8 is going to be met. Because I think lots of this stuff is very difficult to make out summarily. But we'll see. So ground 1 is the one that was sort of marketed as the thing to replace Section 21. It's essentially available if your landlord or a member of the landlord's family wants to move in, which is something we've heard about. I've been evicted on the basis that, I shouldn't say that, I wasn't evicted. I moved out because I got a notice on the basis that my landlord was going to move in. And then lo and behold, I saw a few weeks after I'd moved out, it was on an estate agent website. He was never going to move in. So this is trying to be a little bit more regulated about that. The tenancy must have begun at least 1 year before the relevant date. So that's the date of the notice. The landlord that is seeking possession needs to require the property not just as a place to put his skis, but as his only or principal home, his or her. It doesn't just have to be the landlord, so it can be members of the landlord's family. It's an exhaustive list, so it can't be just anyone. It has to be the landlord, their spouse or civil partner, or someone that they're living with as though they were married. landlord's parent, grandparent, sibling, child, grandchild, or like a stepchild, a child or a grandchild of spouse or civil partner or someone you're living with as though you were married. The act is kind of oddly worded. It says relationships of the half blood count as the whole blood. Gross, but what it just means basically if you're, you know, if you have a half sibling, that counts as a whole sibling, so you don't have to worry about that. If you have a joint landlord, they don't both need to be related to the people that are moving in. It just needs to be one landlord that meets their criteria. So I think there's going to be two areas that you're going to have a fight about. I don't know how it's going to work in the court, but the first thing I think is probably going to be a ground of possession is whether they're genuinely planning on moving in as their only or principal home. So that's the usual occupation test. How you're going to prove that, I don't know. But I imagine when I look at these things in terms of unlawful evictions at the minute, when people are saying they're desperate to try and move back in because they've got nowhere else to live, poor landlords, you tend to look at what other properties they own. And if they own 3 properties in Kensington that look empty, you're going to be wondering why they're trying to move into, I won't say where, but places that aren't Kensington. So that's one way to maybe challenge these ones. Another thing, I guess, though, you're going to become sort of private investigators by the end of this, but having a look at whether they're actually related, half blood or whole blood or any blood. So, because I have had cases where landlords say that they're moving somebody in and they're not related to them at all. So I imagine that stuff's going to be coming up. And this is, I think, the easiest ground to get possession on. So it's probably going to be the one that comes up the most often. As a reminder, it doesn't preclude use of the ground, but Section 16F of the new Act is going to make there be a restricted period of 12 months after you get possession where you can't market the tenancy. So you can't market this, if your landlord gets possession on the basis that he's moving in, or his wife is moving in, he can't then pop it on Zoopla the next day. And there's lots, it's not just tenancies, it's license where the license is being given to you on a condition of money being paid. So they can't just say it's actually just a license. I'm a resident landlord. That doesn't count either. That counts too. And you can't authorize someone else to do it. So you can't get an estate agent to do it for you to beat the law. So that should mean there's a financial penalty if you do that anyways, but it should mean that it's no good to your tenant that's already been evicted, but it should be a disincentive for the landlord to use it improperly because they can't actually market it without committing an offence. Ground 1A. This is the other one that's probably going to be quite common. It's sale of a dwelling house. So they have to be selling the leasehold or a freehold interest or granting a long-term lease, so a lease that's for a term certain of more than 21 years. It's not available if it's an old Rent Act tenancy. In order for the conditions to be met, your current tenancy needs to have begun at least a year before the relevant date, so date of notice, or basically you've got a compulsory acquisition order. So the council's told you, I need to buy your building or whatever. How often does that happen? I don't know, but there we are. The ground is available for you sooner. So before the year is up, if the council needs it, and you've got proof that you're selling it to the council. It's not available to social landlords. And the word sell includes transfer. So I guess it doesn't need to be sold for money. Well done. No, I'm doing it right. Okay, so rent to buy. This is, again, I don't know how often this is going to happen. So it's a ground that's available if you are selling the leasehold or freehold interest, granting a lease for a term certain of more than 21 years, or granting an assured tenancy. But it's only available where the tenancy that you have, that the tenancy for the property that they're seeking possession on, was part of a rent to buy agreement. So rent to buy essentially means they let it to you at up to 80%, I think, market rent, on the basis that they're expecting you to buy it within 5 or 10 years. Or there's different, but basically, this ground is available for people who overstay their welcome and haven't bought the house. So how often does that happen? I don't know. Maybe this is happening all the time in the county courts and I'm missing it. But yeah, I don't think it's going to be too frightening. This is really fun stuff, by which I mean not at all. It's a superior lease ground, so I won't go through them in detail. But essentially, what the Act is trying to prevent is problems where you have a head lease, a superior lease, and then a mean tenancy, and then you have someone down here, so who's been let to again. There's lots of circumstances where that happens. We see that with local authority tenancies. Well, are they tenancies where they are themselves let to by your Wentworth estates, your Waltham estates. So it could come up quite often. It's a good idea to have a look at these grounds properly. But essentially, your defense to all of this is going to be, these are only available where the superior, the superior tenancy is coming to an end. So you're just going to have to look properly about whether those things have been terminated properly. It's the same sort of thing you would normally do. You also have 2ZC, which is about properties that you get as a result of Section 18. So Section 18 is where you're an authorised subtenant. Again, it's only available for certain listed categories of landlords. So you've got your registered social landlords can use it. And then 2ZD is slightly different. Again, it's for tenancies that arose as a result of Section 18. But where the superior tenancy is coming to an end. So it all relies on that head lease going away. So you just have to look about whether that's been terminated properly. Ground 6A, this is redevelopment. You have to meet all of these conditions in order to get the property back on this ground. Landlord must be a relevant social landlord. So there's a set list of who that can be. The property has to be made available to you in order to enable redevelopment of the previous property. So your tenant was living in the property. Landlord said, you need to go so that I can redevelop it. I'm going to put you in this place. That means that they can use this ground. It's basically to get you back into the old place. The previous home has to have been your principal home of the tenant. I've been given a 5-minute warning. The previous home was let by a registered social landlord or a registered provider of social housing. And this ground's only available, have I turned it off? Maybe. This ground's only available where there's alternative accommodation in place. So that's going to be what the fight is about, I think, in this one. So alternative accommodation can either be the home that you were kicked out of previously, in which case there's not much you can say because that was the home, now it's fixed, you can go back in. Or if they can't let you back into that property, they have to offer you a different property. And there's conditions attached to that. So it needs to be a property with adequate security of tenure. That means either assured in the new renters' rights way, which is actually quite secure, or something with equivalent security. It has to be affordable. So either no more expensive than the house before you got kicked out. So if they put in a pool and a penthouse after you got kicked out, they can't say that that's affordable to you. Now it has to be the time before you got kicked out, and it has to be or reasonably suitable to the means of the tenant. So what can that mean? I imagine we're going to be using the same income and expenditure sheet that we use in homelessness. And then also appropriate location has to be reasonably close to the previous home or reasonably suitable to the means of the tenant regarding proximity to work, which I think is quite odd because it doesn't think about proximity to anything else, including kids' schools and stuff, but the ground says work, so yeah. I'm going to rattle through now. Ground 6B, this is an interesting one, but again, how often is this going to happen? It's only going to be available where basically leaving the tenant in the property means that you're going to put the landlord in breach of either a banning order, there's an improvement notice that means that arising from overcrowding. So basically something needs to change. This person needs to leave in order for the landlord not to be committing a crime, essentially. Where an HMO license was refused or revoked, where an HMO licensed property has been occupied by, has been occupied by more than the maximum permitted number of households, so it's overcrowding, or where there's a planning enforcement or injunction, and if you stick around, the landlord's going to be immediately in breach. So again, how often that's going to happen, I don't know. Changes to the existing grounds, finally. Holiday let ground is gone because it's replaced by other things. Ground 8. So there were talks about when they first mentioned the RRB coming in, there was an idea that they wanted to catch out tenants that, who are these tenants? I don't know. I've never met one that are just consistently getting to the level where they're above ground 8 and then they show up to court and they make a payment and then, whoa, they're off scot-free. I just think that's an invisible problem. I think that doesn't exist, but it doesn't seem to be reflected in the new ground 8. So what actually happens is now it's gone from you know, your normal 8 weeks to 13 weeks unpaid, so it's higher. You've got, yeah, so it's either 13 weeks if you pay weekly or 3 months if you pay monthly. So it's nicer than it used to be. And also, very lovely addition. Basically, if the reason that you're in ground 8 is because your local authority hasn't paid your housing benefit or universal credit is in delay, ground 8 is not made out. Lovely. Again, yeah, the Landlords Association must be crying, but let's see. Ground 7 hasn't changed much, except for, so ground 7 is death of the tenant, where nobody has succeeded. This is the last thing that I'm going to talk about. It will only, if the new tenant is occupying the dwelling house as a new tenant's only or principal home immediately before the death, you can't make an order for possession unless the tenancy is devolved as part of a will or intestacy, or the tenancy is a special tenancy. So what is a special tenancy? It includes ones granted by a private registered provider of social housing. It's a rent to buy type tenancy. It was a tenancy granted in compliance with section 193 of the Housing Act 96. It was supported accommodation, or it meets some conditions in ground 5H, which Dominic is going to talk to us about later. So that's the sort of beginning of the new landscape for possession proceedings. I think I've probably gone way over my time, so I'm going to pass on to Cara.
Very good. Thank you very much, Marie. So I'm going to pass on now to Cara Hall, who is the newest member of our team in Chambers. She also arrived in Chambers with an impressive wealth of experience working on the front line of housing law work at Citizens Advice in Kent. She's also very much already a rising star in the field, developing an impressive reputation across the range of housing law work in Chambers. And Cara is going to talk to you, as I said, about the provisions relating to the enforcement of landlord legislation.
Thank you, Dan. So in part 1, which I think some of you were at, we looked at all of the new obligations that are being imposed by the bill. And so the question then becomes, who's responsible for enforcing those obligations, and what will enforcement look like? And the bill's clear that it falls squarely on the shoulders of the local authority at clause 107. But what's quite interesting about what the bill does is that it is also clear that local authorities can take enforcement action in respect of breaches outside its own area, provided it gives notice to that local authority. But also county councils who aren't local housing authorities can also take enforcement action. So basically anyone can take some enforcement action. And I think it's just trying to make sure that as broad section of local government is able to take action in respect of these new obligations. And then in respect of what enforcement looks like, it's usually either some sort of financial penalty imposed by the local authority, or it's a summary criminal conviction, which always results in a fine, except for unlawful eviction, for which you can go to prison. The rest is a fine. To help them with their enforcement, the bill also has really expansive investigatory powers for local authorities. And I initially wrote a slide outlining some of them, but it was so dull. But do have a look at clauses 114 to 129 of the bill, because I have no doubt in my mind that we're going to need to explain to these local authorities what their own investigatory powers are. As we all know, they don't do what they have powers to do. So we need to make sure that we know what they should be doing so we can tell them to do that. But broadly, it includes things like asking for information from certain people. They can even go to court to obtain information if needed. And they're also able to enter both business and residential premises for the purpose of any function under the legislation that's specified within these clauses. And that can include without a warrant in certain circumstances. So again, have a look at these clauses if you've got a local authority not taking any action, so you can tell them what they can and should be doing. Next, it's a question of who is enforcement against. And again, I'm afraid it's going to be a matter of looking at the individual new obligations, because some are required by relevant persons and some are only required by landlords. So some can be more broadly enforced than others. In respect of what a relevant person is, there's a new section 16M going to be inserted into the Housing Act 1988, which includes the landlord, a person acting on behalf of the landlord, otherwise than as a legal representative, or a person purporting to act on behalf of a landlord. So that's pretty broad, but it will be important to check each provision carefully because some only apply to landlords. Now, we looked at all the specific obligations last time, so I'm not planning to go through them all again, but the enforcement powers are huge, and effectively, the local authority can take action in respect of basically all of the new obligations that are imposed on landlords. And in terms of what enforcement looks like, it's usually a financial penalty of up to £7,000 unless the breach constitutes an offence. And there's certain offences which I will run through very briefly with you, but effectively I've tried to provide a sort of crib sheet within my slides, which I hope have been sent to all of you or will be, so that when you've got landlords in breach of their obligations, you can look at these and figure out, okay, what should the local authority be doing and what's the penalty for this breach? So in terms of offences, so there's going to be a new section 16J inserted into the Housing Act 1988, which provides for some offences, which includes where the landlord, well, a relevant person, so again, someone purporting to act for the landlord or someone acting for the landlord, if they rely on a ground for possession, which you've just heard about from Marie and we'll hear even more about from Dominic, knowing that they would not be able to obtain an order for possession on that ground, or being reckless as to whether the landlord would be able to do so, and the tenant actually surrenders their tenancy within 4 months of the date the ground was relied on. There's also an offence where they contravened section 16E and section 16E3, which is basically where they've relied on grounds 1 or 1A as outlined by Marie, and then they relet or remarket the property within the relevant period. That's an offence. So that's quite exciting, and hopefully will discourage them from relying on this ground when actually they have no intention of moving in or moving a family member in. And there's also an offence where a financial penalty has already been imposed by the local authority, but the conduct for which that penalty was imposed continues after 28 days, or finally, where they conduct themselves in a manner giving rise to a financial penalty under section 69, which I think was on the previous slide, but basically if they do further conduct within 5 years, that's also an offence. Now, in terms of the consequences for these offences, you can either be tried on as a summary offence and imposed with a fine, or the local authority can impose a financial penalty of up to £40,000. So that's quite exciting, but it is either or. You can't be convicted and impose a financial penalty unless you've been imposed with a previous financial penalty and then you continue the breach. So it's either or, not both. But you can also seek a rent repayment order for these breaches. So that's probably more of more excitement for our tenants. And you don't even need to have been a tenant at the time in terms of the offences under 1 or 2. So if you've given up your tenancy, they got a possession order on grounds 1 or 1A, and then they breached it, you can claim a rent repayment order back for when you were a tenant, which is pretty cool in my opinion. Then, sorry, that's financial penalty. The next one that deals with offences is clause 93, and this relates to the database, which we had David Cohen spend quite a bit of time talking about last week. And we don't really know what that's going to look like yet, but there are offences in respect to the database to try and make sure that landlords are on it and doing what they are supposed to. So if they knowingly or recklessly provide information to the database operator which is false or misleading in a material respect, that's an offence. Or they've previously breached their obligations in respect to the database, and they continue to, so for example, they've not provided information, they're served with a financial penalty for not being on the database, and then they continue to not be on the database, that's an offence as well. And again, if they engage with further database breaches within 5 years, that is also an offence. And again, this would either result in summary conviction with the imposition of a fine or a financial penalty of up to £40,000. So again, really trying to incentivise landlords to comply with their obligations in respect to the database. And you can also seek a rent repayment order for these breaches. Unlawful eviction, I've not gone into this in particular detail because it's not changed massively. The only thing that's changed is that now, rather than conviction, the local authority can also impose a financial penalty. So that may be something to encourage when you've got cases involving unlawful eviction, and that's been amended within the Protection from Eviction Act. But again, it's either or, so the landlord can't be imposed with a financial penalty and sent to prison. It's one or the other. So in terms of what applies broadly to the financial penalties, there's some provisions that are basically repeated throughout all of the sections that impose penalties. So as I said, it's either or. You can either be convicted of an offence or you can be given a financial penalty, but not both in respect of the same conduct. If you do a later breach within 28 days or 5 years, depending on the specific obligation, then that can be a new offence or a new financial penalty. But again, you can't have both in respect to the same conduct. Where the offence is by a body corporate and attributable to an officer of that body, both the body and the officer commit the offence. So that's quite exciting. I find you often get a bit further when you can attach it to a specific person at the local authority or social landlord, and that can be very helpful to do. So I think this is a welcome provision. As I say, for conviction, it's always a fine as the penalty. No sending housing officers to prison, unfortunately, unless it's unlawful eviction, for which you can go to prison for up to 2 years. In respect of, oh, sorry, I think I did the wrong slide. Sorry, everybody. In respect of financial penalties, they can be imposed jointly if 2 or more people have breached the relevant provisions. You don't need to pick one. All provisions which provide financial penalties, every single one of them gives the Secretary of State the power to give guidance to local authorities about the exercise of that function. So that remains to be seen whether that happens. It may be that the landlords complain about how the local authorities are doing it, and the Secretary of State may provide some guidance. But again, we'll just need to wait and see what happens with that. And then in respect to the proceeds they make from imposing these financial penalties, they can basically spend it on whatever they like in respect of enforcement or in relation to the private rented sector. So that's pretty cool in terms of expanding their funding, and it will be in the local authority's interests to actually spend it on those functions. Otherwise, they need to give it to the Secretary of State. So that's the slide I meant to show you, and that's the one I accidentally spoke about first. And then in terms of what enforcement actually looks like, so what the bill does is it amends the Housing Act 1988 to add new obligations and new penalties. It also amends the Protection from Eviction Act. And then within the bill itself, there's obligations and penalties. And within each of those pieces of legislation, it's added in a new mechanism for enforcement. And effectively what that looks like is that firstly, the local authority has to give the landlord a notice of intent of imposing a financial penalty before they actually impose it. And that has to be within 6 months of the conduct. So again, it's going to be in our interest to be making sure that the local authorities know what they can be doing and what they should be doing, and that 6 months just doesn't disappear and then suddenly they can't take any enforcement action anymore. After that 6 months, and obviously some conduct's ongoing, so if it's ongoing at 6 months, it doesn't, keeps going. In terms of what happens after that, the landlord then has 28 days to make written representations to local authority, which inevitably will say, oh, I didn't know that I had to do that. And then the local authority gives a final notice, which is when the penalty is actually imposed. And the landlord or the relevant person or whoever, they can appeal the decision to impose a penalty to the first-tier tribunal. So that's going to be interesting. Maybe Siobhan can give her views on what that might look like. But effectively, they can either challenge the amount of the financial penalty or the imposition of the penalty completely. And then if the landlord doesn't pay the financial penalty, the local authority can actually recover the same as if it was a county court judgment. So again, no penalties being imposed that aren't actually going to be enforced. And again, probably worth outlining to local authorities. There's no point imposing financial penalties if you don't actually recover the same. Nearly finished. Just a little bit on rent repayment orders. So I discussed briefly along the way that you can seek rent repayment orders for some of these new offences. So that's been amended within the Housing and Planning Act 2016, Section 40, which deals with rent repayment orders and outlines all the offences that one can be sought for. It also increases the sort of like limitation period for seeking a rent repayment order to 2 years. So you've got a bit more time to be getting those. And you can also get a rent repayment order now more easily against a superior landlord because that's been amended within the Housing and Planning Act as well. Because obviously we've all seen those cases reported on Nearly Legal where there's a massive dispute about who should have been doing what. And again, you can seek a rent repayment order both against a body corporate and an individual officer of that corporate body, which again can encourage settlement because once you attach an actual person to it, I do find you get a bit further. Finally, just a brief note on gas safety. Those of you who were here last time will know I was asked a question last time and I said I'd specifically deal with it today. So there's nothing in the bill specifically about gas safety. And I think the concern that was expressed last time was with the abolition of Section 21, how is it going to be policed? I think the point that I made was defending Section 21 proceedings on the basis of gas safety isn't a good way to police it anyway. But there's no provisions directly in the bill, so it seems that existing mechanisms will continue to apply in respect of gas safety. So complaining to the Health and Safety Executive, who could serve an improvement notice and the like. And it may be that we need to go down that route a bit more, given that we're no longer going to be dealing with it in Section 21. But yeah, no changes in the bill itself to gas safety. And that's it from me.
Thank you very much, Cara. That was a very interesting presentation. I think in relation to equally significant changes, which are perhaps have been put in the shadow of the headline of the abolition of no-fault evictions. So very interesting to hear about. Next, we're going to come to Dominic Preston to talk about possession claims in relation to certain protected sectors. I've often fallen into the error of introducing speakers by saying that they need no introduction and then going on to give a long introduction anyway. So Dominic falls very squarely into that category, and I'm just going to go no further than the words of Chambers and Partners, that as a barrister, he is, quote, simply a go-to for any credible housing lawyer. So in a shameless attempt to reinforce my own credibility, over to Dominic.
Well, in that case, I hope there's still a few credible housing lawyers left, and then they can instruct me. I noticed that our fourth speaker, Siobhan, is sitting at the back. And I'm slightly wary of that. I was hoping she'd be even later. Because as her pupil, I remember her looking at my work and saying, too many words, Dominic, too many words. So when you look at my slides, can I just say I didn't really listen and apologize? I have put as much as I can in the slides in the hope that as I skip through in the 15 minutes I've been allocated, you will get these a little bit later and you will be able to ponder them in a little bit more detail. As I said before on the last occasion, the provisions in the bill are really quite extensive, and you will need to go to them again and again, I suspect. So why have we split up the grounds into two different sections? As I said on the last occasion, there are these areas in which Parliament decided, or government decided, that they wanted to keep insecurity of tenure for these particular areas of housing, effectively to ensure that there's a continued supply. I've called them protected sectors. I could have called them something else. No doubt as time passes, somebody else will come up with a better phrase. but they are effectively students, tied accommodation, supported accommodation. I've included in there stepping stone accommodation and homelessness. And so those are the 4 areas that I'm dealing with. I've set out a summary there of the grounds, but I'll go through those in a little bit more detail. Some general points just before going to the grounds themselves. And as you look at that slide, you think to yourself, yes, definitely too many words. So protected sectors also benefit from exclusions from Schedule 1 or exclusions from security of tenure. And if you were here on the last occasion, you'll have seen we covered that. Otherwise, just grab hold of our slides. Grounds 4, 5 to 5.8, that's about 4 or 5 grounds, and 18 require what's called pre-grant notices. And that's in a new section 16D. It's no longer set out in the grounds themselves, so you do need to occasionally check 16D to see which ones do require a pre-grant notice. What do I mean by a pre-grant notice? Before the tenancy is granted, the landlord must give notice in the statement of terms, referred to by Cara, that there is a potential intention of using that ground at some point later on. So quite a few grounds now have this pre-grant notice requirement. And in the absence of a notice in the statement of terms, it is a breach of the landlord duty to make any claim on any of those grounds. And as you've heard from Cara, there are fines involved in any breach. There is one additional ground that requires what I've called pre-grant notices, but in respect of which a failure does not have any consequences other than potentially having to ask the court to dispense with the notice, and that's ground 4A. Schedule 2 of the Housing Act also includes a couple of provisions that you're going to want to go to. One is a definitions provision in paragraph 13. You may not want to go to paragraph 12 rather for definitions. You may not necessarily want to go to paragraph 13, but be aware that the Secretary of State can play with these provisions, and no doubt as things develop will do so. So some of those grounds can be amended. Let's deal quickly with student accommodation. And again, a reminder, there's a new Schedule 1 paragraph 8 exclusion from security of tenure for any tenancy granted by certain specified landlords. And the key important one there is that private landlords who sign up to a code of conduct can grant these tenancies. And so it's granted by one of those landlords to persons pursuing or intending to pursue a course of study. So that accommodation is excluded from from security of tenure. Why am I going on about that? And that's because ground 4 is a ground that is intended to preserve that accommodation that's used in that way, so that it can be re-let to students without having a period in which no rent can be claimed. So if in the preceding 12 months the property had previously been let on a Schedule 1 paragraph 8 tenancy, then it can be reclaimed for that purpose. That's ground 4, and again, reminder that this is one of those grounds in which notice of use of intent of that ground must be given. And the point of that notice is to say effectively to the tenant, look, you're taking up a tenancy which might have a little bit less security. Are you sure you really want it? Like a student is going to care. So, students' mandatory ground 4A. So this covers other landlords effectively, and it applies where all tenants are either full-time students at the start of the tenancy, or the landlord reasonably believes that they will become students during the tenancy. Student must be on one of the specified courses. That basically means degree level or above, and prior written notice of intention to use ground 4A must be given. This is the ground in which there's no consequence other than the ground doesn't apply. The time between the contract and the start of the tenancy must be 6 months or less. These tenancies, as I'm sure as you know, tend to be granted between August and September, and they must not be granted more than 6 months beforehand. And if the landlord must intend to re-grant the property to other students after recovery of the property, And lastly, the Section 8 notice requires possession between the 1st June and 30th September. So if you do get any students with private landlords to turn up, just hope to God that the landlord didn't read all of those provisions. Let's look at key worker accommodation. Again, I've done a summary. You'll not be surprised if I skip 5 and 5A quickly. One relates to minister of religions and one agricultural workers. 5B is again a preservation of supply ground. It's where the accommodation is generally used for persons who meet requirements connected with their employment, and the landlord wants it back to use it for this sort of accommodation. Ground 5C is a tenancy that's aimed at the tenant, where the tenant has that tenancy in consequence of their work or employment. And ground 5D is a tenancy that applies where the tenancy is let to the tenant who meets the requirements set by the landlord that are connected with their employment. There's a key feature in these grounds, and that's generally that it's the landlord who decides what's important for that local area, and they can set the criteria provided it's connected with employment. So it allows them an enormous amount of flexibility to bring accommodation into that area. Ground 5D also requires that tenant no longer meets those requirements, and the tenancy was granted by a registered social landlord. All of those grounds require a pre-grant notice. I'm going to just deal with 5C in a bit more detail. It was previously ground 16, which was discretionary grounds, now ground 5C mandatory with some additional provisions here and there. But if it applies if the tenancy is let in consequence of the tenant's work or employment, applies whether it's that self-employed or employee. It applies to someone as well who holds an office of constable. That's because police constables are employed in a slightly odd way. And the landlord and the employer need not be the same. And then the two additional conditions: the tenant's employment must have ceased, or the property was intended only for an early period, by a sort of starter tenancy to get people into the area easily, and then they can move on to more secure accommodation. And that period has come to an end, and the property is now wanted by the landlord for another key worker of one sort or another. So 5C is really the main ground, which gives that flexibility to landlords to sort of, I think landlords, but also local employers, to work out what is needed for the local area and use accommodation for that purpose. I'm going to deal with supported accommodation next. Lots of grounds. 5E is again a preserve the supply of accommodation, but nevertheless you're allowed to let it out to others for a period. 5F is let as supported accommodation. I'll come to that in more detail. Ground 18 is a discretionary ground where it's let as supported accommodation and the tenant has unreasonably refused to cooperate with provision of support services. And ground 5H is a stepping stone accommodation, so applies to a wider bracket than supported accommodation, but I've sort of included it in this sort of heading, as it were. And it does have extensive conditions, but just to say, it's aimed at accommodation that we're quite used to seeing: refuge accommodation, prisoners on paroles, what you might call halfway houses for them, people recently released from mental health patients. So it's that stepping stone accommodation where people need support to get back on their feet. They need that accommodation and they move on. So it tends to be for a limited period. I'm going to look at ground. Actually, no, first of all, just deal with the meaning of supported accommodation, which does need some explanation. So if you're in the care sector, supported accommodation can mean all sorts of different things, but this, in the context of possession cases, it does have a specific meaning. It is supported accommodation if it is let by a housing association, a private registered provider of housing, a registered charity or voluntary organisation, and the tenant receives care and support or supervision, which is provided by the landlord or a third party. Where it's a third party, the purpose of the grant needs to be the provision of that care by the third party. So we see that sort of accommodation, I think, quite a bit. It's not an unusual, well, it's a very common thing to see, but it has here got a very specific definition for the purpose of dealing with these grounds of possession. Now, the reason I've gone to ground F is really 9 more grounds, just for fun. And it gives you a sense of the of what the sector is currently doing, and it's just an attempt to replicate and allow that flexibility for this particular sector. So it applies if property was supported accommodation when the tenancy was granted, and then we go through A, B, C, D, F, G, whatever. A is it was granted to secure support for a limited period, and that period has expired. The third party provides support services, but support has ended or is not being provided, and the landlord can't find an alternative source of support. So if that third party effectively pulls out, then the landlord has an obligation to find someone else to step in, but if they can't, then they can move that person on. Funding for support of accommodation was from a third party, and the landlord can't find alternative funding. It's not not reasonable for the landlord to provide the accommodation or support themselves. And D is where the project, or indeed the financial zone, the landlord's own financial viability is threatened, and the landlord cannot secure alternative funding. So you can see there that it's about the practicality of getting support, its availability, and the funding that goes with it and that is needed. If any of those things fall through, the landlord has to find some alternative. But if they've taken reasonable efforts and they can't find it, then they can move the tenant on. Then we've got, again, this is still ground 5F, but it's 5 other separate grounds, and this is where the supported accommodation effectively doesn't meet the tenant's needs anymore. And you can see the 5 different ways in which the Act looks at the possible ways in which the accommodation is no longer, sorry, the purpose of the grant of the accommodation is no longer being met. I'm just going to do, I think this is my last slide. I've had a 5-minute warning by email, and I think somebody's kicking me under the table. So just homelessness. I dealt with this on the last occasion, but it's worth mentioning again. The aim here is the recovery of Section 193 temporary accommodation secured in the private sector. I've set out the conditions there. I went through it on the last occasion, but I've tried to do a mathematical calculation and worked out that basically any Section 8 notice has to be served within 48 weeks of the local authority saying, oh, you can kick that person out of the Section 193 accommodation. So have a look at those provisions in a little bit more detail, but hopefully I've got the gist of them there. And I do believe that is it from me. Siobhan, I'm afraid you're up.
How long ago was it, Dominic?
It was yeah, last week. I'm pretty sure it was last week. Okay.
Thanks very much, Dominic. Now, finally, I'm delighted. There's literally no better person to talk to you about the role of the First-tier Tribunal Property Chamber, as she is the president, as you know, of that tribunal. Prior to her appointment, she was the senior president of the Residential Property Tribunal Service for 13 years, and before that, she was a barrister specialising in housing and landlord and tenant law. She's edited a number of publications, including the Housing Law Encyclopedia and the Housing Law Reports, and she was a part-time lecturer at the London School of Economics. She also sits as a recorder in civil and chancery jurisdictions and is a deputy High Court judge. So thank you very much for joining us, Siobhan, and over to you.
You're very welcome, and I'm tired just listening to that. but I won't worry about that. I wasn't here last week, and I missed the very beginning of this week, but in case it hasn't been said, this legislation is the most radical change to security of tenure and other aspects of the private sector, private rented sector, for more than 30 years. It is quite extraordinary. And I think that what we will see eventually is a complete change in the way that you deal with the private rented sector. At the moment, my impression is that there's an awful lot of firefighting all the time. There is a great deal of looking, for example, because of the Deregulation Act, at the fine details of notices. That will still stay, but it'll be different. It'll be very different. And one thing I can say was it used to be, prior to January 1989, and indeed prior to the commencement of the Housing Act 1996, quite a lot of fun doing possession proceedings. It's a great time. One of my favourites was a landlord who was a landlord by purchase. It was the old Ground 9 under the Rent Act 1977. And he had bought this property and he said he wanted the accommodation upstairs from a tenant who'd been there for many years. The tenant had been there for many years, kept in a one-bedroom flat, 5 dogs, 6 cats, 2 tortoises, a few fish, a couple of snakes. Anyway, so eventually this came to, at the time, Bow County Court in front of a lovely judge called Judge Tumin, and I was taking my client who was the person who was been seeking to be evicted, and it got to the tortoises. And she said, well, the trouble is you can't make me get rid of my tortoises because they're anorexic. So Judge Tumin said, well, how do you feed them? She said, very slowly. And also, it was very possible to succeed in defending possession proceedings. So there's been an awful lot of technical talk, a lot of detail, but of course, when it comes to it, it's one case at a time. So far as the tribunal is concerned, I am guessing some of you have never heard of the First-tier Tribunal. Never mind, she's the best person to talk about it. First-tier Tribunal Property Chamber has been around for a long time. In its present guise, only since 2013. But we do a huge range of cases. We started off doing rents, but we hardly do any rents at all. We deal with leasehold property, management, appointment of manager, variation of leases, which came off the county board, service charges, administration charges. We deal with enforcement by local authorities. This is not new. They already serve financial penalties where, for example, landlord doesn't have a house and multiple occupation license, or where there's additional licensing or selective licensing for many other types of accommodation. Local authorities already impose those financial penalties. They come to the tribunal. We already deal with applications for rent repayment orders, and I'll come to a couple of points about that in due course. And most recently, and most interestingly, we've been given jurisdiction under the Building Safety Act to deal with those cases in relation in particular to higher risk buildings. And this all emanates from the problems which were identified following the Grenfell Tower fire. They are fascinating cases. The range, what we deal with rents, say in Manchester, we are a national tribunal. We have 5 separate offices. It might be rents, I don't know, the difference between £30 and £40 a month. I have a Building Safety Act case coming up in the next couple of weeks, just a case over here, where the cost of the works will be £440 million. The range, what we do is huge. We sit with specialist judges. If you'd like to apply to be a fee paid judge, you'd be very welcome to do so. That would be excellent. Thank you. I'm absolutely serious. We really need as many judges as we can get because of what is coming down the road. And it's the best tribunal. It's really good fun. And we sit with experts, valuers, surveyors, environmental health officers, some architects, building safety experts, and we have lay members. We try and get through the cases quickly. 75% of those who come before us are not represented. And that is why it's important to have a specialist tribunal. So what is the Renters' Rights Bill? And it is a bill, so I have to keep caveating what I say with, this is what it says at the moment. But what it says at the moment indicates that the caseload of the tribunal, which is currently in residential property part of it, about 13,000 cases a year, will triple to about 36,000 cases a year within the next 2 or 3 years. And I think that it is quite possible that that is an underestimate for the reasons I will tell you. So where is the bill? The bill is sitting in between the House of Commons and the House of Lords. It goes back to the Lords, I think it's the 14th of October, because they have to consider what the Commons said about the amendments that they made to the bill. It's a procedure known as ping pong. And once it finishes doing ping pong, get royal assent, and then we will see when commencement will be. So this government is very, very keen, certainly to get the security of tenure and the rental sections and provisions in the bill up and running and up there. The intention is at the moment, if you look at the bill, that it will apply both to existing tenancies and to new tenancies. There are going to be questions for you as to, for example, if possession proceedings have already started, which regime will apply. It may be that we will see transitional provisions. There are a lot of complex forms that have to be designed. There will be complex secondary legislation. So after royal assent, there is likely to be a gap before the Act actually comes into force. When it comes into force, for the tribunal, the impact may not be immediate, but the biggest impact will be in rents. So, as I'm sure you know, at the moment, landlords can have a clause in a tenancy agreement which allows them to put up the rent at particular intervals, usually yearly intervals. At the moment, tenants and landlords can agree that the rent should go up. In the future, there will be no fixed-term tenancies, as you know. It will not be possible for landlords and tenants to agree to a rent increase unless what's called the Section 13 notice procedure has been followed. And as we've heard already, a failure to follow those rules could end up with a financial penalty. So what does that mean in terms of caseload? Why do I think that will make a lot of difference? At the moment, it is said, and it's probably quite a convincing argument, that tenants do not use Section 13 to challenge a landlord's notice for a number of reasons. One is they are concerned with retaliatory Section 21 notices. Secondly, they may be concerned that the rent could go up higher than the rent specified in the landlord's notice. And thirdly, they're concerned that by the time the tribunal makes its determination, they might have built up arrears because the effective date and the date that rent will be recoverable from is the date in the landlord's notice. What the bill says, first of all, it abolishes Section 21. So it may be that tenants will think, well, actually, I'm not likely to find myself with a notice which I can't defend, going to the county court, having to leave because Section 21 has been abolished. That's one possibility. Secondly, the tribunal will be able to set a rent, a market rent, because that's what we have to set, above the amount in the landlord's notice, but the amount that will be recoverable is capped at the amount in the landlord's notice. And thirdly, at the moment, as the bill is drafted, the rent increase will not take effect until the tribunal has made its determination. There are 5.5 million, approximately, private rented sector tenancies. I think you can do the maths. I think it's going to be more than 36,000 in the next 3 years. We'll see. I'm very calm about all of this because I've been doing this a long time, and having seen that when law changes or when new provisions are introduced, it takes a while for matters to settle down. And we are working with HMCTS and MOJ and MHCLG to get matters ready so that we will be ready when the cases start to come in. So that's a big thing. In addition, at the moment, there was a Court of Appeal case a couple of years ago, Mooney and Whitehead, which said that challenges to the validity of a Section 13 notice are for the county court. Now, I think that's half right, but I also think that we have the jurisdiction to decide our own jurisdiction, so we can take a view on a notice, but that's not binding for every purpose. The bill will introduce a new power and a new jurisdiction for the tribunal to determine the validity of Section 13 notices. Other provisions affecting the rents at the moment, usually a landlord will have to give a month's notice of intent to put the rent up, if you like, Section 13 this month. That will be extended to 2 months. Although it was said very clearly that the Act was not intended, talking about the Housing Act 88 and the changes brought by the Renters' Rights Act, not intended to impose any form of rent regulation, it will be interesting to see what effect some of these changes have on market rents. Just changing security of tenure all by itself will change market rents. So although it might seem a very, I don't know, not a very exciting part of the bill, it is likely, I think, to have quite a big impact. We've heard about civil and civil penalties as opposed to prosecution, and I won't say very much more about them, except to say that we are already dealing with them. It is interesting, the figures are interesting. Penalties may be up to £7,000 for first or minor non-compliance, but for serious or repeated non-compliance, they may increase up to £40,000. Now, that's a lot of money by itself, but when there is a landlord who may have been guilty of more than one offence, that adds up very quickly indeed, and might act as a disincentive not to comply with the provisions of the Act. So I just want to give you a list of the new financial penalties. These are on top of the ones we do already. Increasing the rent other than by the Section 13 process. If you don't use Section 13, then you are liable if local authorities are given the funding to enforce a fine of up to £7,000 or ultimately £40,000. Discrimination in tenant selection. We'll have to know about discrimination law. I've already got somebody lined up to teach us. Breaches of obligation relating to the private rented sector database. Purporting to let for a fixed term, because you can't have any fixed terms anymore. Failing to provide the tenant with the written terms or statements of a tenancy. Failing to state a proposed rent. Breach of a prohibition of the rental bidding rule. Asking for or accepting prohibited pre-tenancy rent payments. Breaches of obligations regarding the new PRS landlord ombudsman. Breaches relating to the very important decent home standard, category 1 hazards, and serving invalid notices or misleading tenants about possession. It's very, very, very wide. It just depends on how that enforcement is used. I just want to go back to the decent home standard for a moment. That will be based on the Housing Health and Safety Rating System, HHSRS, which was introduced initially by the Housing Act 2004, and the tribunal already deals with HHSRS applications by landlords, for example, appealing against improvement notices or on prohibition orders, etc. So we're in a good place to be able to decide, has there been a breach of the decent home standard? Rent repayment orders, we've already mentioned, they can be very, very effective. It is interesting, we get a lot of rent repayment orders already because already there are housing offences which trigger the right to get a rent repayment order. At the moment, a tenant can only seek, if they are successful, 12 months backdated rent or rent repayment. And that will change, as we heard already, to 2 years, which is a very significant increase. And in response to the original rent repayment orders, which were brought in by the 2016 Act, landlords, unscrupulous, it's not true of all landlords, some unscrupulous landlords started to set up rent-to-rent schemes so that they weren't actually in receipt of the rent, and therefore the person with the money couldn't have a rent repayment order made against them. That will change so that it's setting aside a Supreme Court decision called Rakusen. It will change that so that the tribunal will be able to decide that a superior landlord has to repay the rent repayment order that we have made. Oh, there's 6 more offences added to the Housing Plan Act 2016. This is for rent repayment orders. Continuing or repeated breaches of the landlord redress scheme, provision of false information on the private rented sector database. You know, putting on the, who knows what's going to be on that database? It might be the market rent. And if a landlord would say, actually, it's more than it really is, that could trigger a financial penalty. Continuing or repeated breaches of requirement of the private rented sector database, knowing or recklessly misusing a ground for possession, breach of restriction on the letting or market of a dwelling house, continuing breaches of tenancy reform. So, as I said at the beginning, the changes to the private rented sector will be very significant. I think it'll take a while till it settles. It's all very well to say that tenants have these rights, landlords have these obligations, tenants have these obligations, but how that information gets out into the consciousness of those who are either landlords or tenants in the private rented sector is, I think, another question. I was discussing this with Generation Rent the other day. Take rents. It may be that a tenant will say, I'd rather agree a rent with my landlord than take the strain and the risk of challenging a Section 13 notice. So maybe I won't have 250,000 rent cases.
Thank you very much, Siobhan. And if I can ask you to join me in thanking all of our speakers for fantastic talks. We're going to now move to have some questions before the refreshments. While I think there is a roving mic that's just arrived, I've got one online and then I'll go to Vicky in the room. And the one that's come through online for you, Marie, is where a landlord does not have an active entry on the database that you discussed. Is the penalty going to be that the landlord can't get possession, or is it going to be that they can't serve a valid notice seeking possession? And if it's the former, does that mean that the landlord doesn't need to be in compliance at the date of the notice and can, in effect, correct the non-compliance?
That's a good question. Let me look back at Section 7. I think it's that the wording of Section 7 now is may not make an order for possession. So I think that implies it's when you make the order for possession rather than the way it used to be with Section 21 where it invalidates the notice. What was the second part of the question?
Well, that was it, effectively.
Okay.
but that means that they could, in principle, cure compliance, do you think, between the date of the notice and the date of the date of the hearing? It also, I suppose, raises the question about what happens between if you put in a defence and it's at the date of the hearing. But I don't know if anybody else has any views on that.
I just wonder whether it'd be worth checking whether they can serve the notice seeking possession or whether they'd be in breach of their landlord duties. I.e., if you cannot claim possession, would that itself be a breach?
That may well be
worth checking
the
way
defence.
the words are
Yeah.
drafted.
Vicky.
It's a question for Dominic about existing supported accommodation, and if you have to give notice that it's going to fall within that regime, how does it work with existing supported accommodation sector?
So everything gets converted, but if you've served an existing notice, you get 3 months effectively. It's not quite, there are some additional provisions depending on what notice you're serving, etc. But you effectively get 3 months in which to issue proceedings in respect of that accommodation. If it's beyond that 3 months, those new grounds are all available to you. And if you meet the provisions, it doesn't matter when the grant was, then that's fine. There is, in terms of I think the transitional provision, I can't quite remember how they work, so that there's no need to serve a notice, a pre-grant notice, bearing in mind that prior to the commencement of the Act, there is no such thing as a statement of terms. So, but for that transitional part, everything's up for grabs.
Any other questions in the room? Okay.
I have one question for sure.
Hi, this is going back to Marie's presentation. So ground 1A, the sale of the dwelling house, does that really bring an end to the concept of a sitting tenant? And having to, like, thinking if you're an assured tenant, you've basically got a tenancy for life, even if you're landlord changes?
Oh, I suppose. Well, it would only be the case if they use the ground. It's sort of a development of an existing ground, I think. But yeah.
Why wouldn't you use the ground if you're the landlord? You
Yeah,
get
it
a
makes
lot
it
more
makes the
money for
property much
selling
more
a property
valuable.
that's vacant.
Yeah, but the only sort of disincentive for that is that restricted period where you can't re-let it. But yeah, I think so. There's other thought.
Dominic, are you?
No, just thinking about the types of landlords that we have. You know, there are professional landlords who have, you know, wide portfolio of properties, and they'll probably sell them from time to time, but most of the time they're looking to get a rent from them. And whether they're good landlords or bad landlords is another matter. But that's not the same as, for instance, somebody who's got one property, the mortgage has gone up and they suddenly need to sell. And equally, even small landlords who are using right to buy, depending on whether there will or won't be any impact on the market rents, I would have thought that their incentive to sell is going to be relatively limited because they're only going to get another assured tenant in, and it's going to be a relatively similar situation. So I suspect, you know, what's the incentive to sell, to my mind, unless there is a reason financially that they need to sell, whether it be mortgage or whatever it might be. If it's just a question of selling and buying another property so as to get rid of a tenant, that seems to me balmy, bearing in mind stamp duty and all the rest of it. Sorry, I had a question for Siobhan, if that's all right.
Yes, please do.
You mentioned market rents and whether or not there might be a dampening effect, or whether or not there might
It
be.
may be the other way, I don't know.
Well, I was. Is there any sense at the moment in terms of setting Section 13 rents at the moment? At tribunals, do they tend to be relatively generous? Do they tend to be relatively?
No, tribunals set market rents. But that is the job. So it's actually in the definition in Section 14 what a market rent is. It is the rent that a willing buyer and a willing seller, or tenant and landlord, will pay for that particular property on the market at the time.
And the second question is, do the landlords, so this is the dampening effect. You mentioned the dampening effect of tenants not necessarily wanting to challenge, but suddenly all landlords are going to have to, in order to get an increase in their rent, are going to have to apply. And not many landlords, well, I would have thought that the large majority of landlords do so by regrant of tenancies and shifting
But that won't be
people on.
possible. It's in
And, well, that's my point. Are they going to find the effort of the application process a dampening effect? Might they just say, "Oh, let's just leave it"?
I don't know. I don't know. I think what you were saying just a little bit earlier is important. Is that, you know, it's a huge sector. It's about a third of the households in the country that are rented property, and a huge number of those households go on very, very happily and get on fine, and the landlords are fine and the tenants are happy. It'll be interesting to see what happens in those environments. It might be, as long as the Section 13 process isn't too difficult, then it'll be something that is done. And it is possible for landlords who serve that they don't apply, they serve the notice, and then the landlord and tenant can make an agreement. It's just that the Section 13 notice process has to be engaged in the first place.
James.
There's a lot of landlords in East London, and I suspect elsewhere, who are giving tenants notice, and this would include homeless applicants, because they're cashing in big time on asylum accommodation and making a small fortune. I'm rather assuming that nothing about the Renters' Right Act affects that.
The existing exclusions in relation to asylum,
Yes.
As you can imagine, they continue to apply.
Yeah, the scam continues, unfortunately.
And Diane at the back. I think might make this the last question, unless there are any burning issues, just because I don't want to deprive anybody of the time to follow up with further discussion over drinks.
It's a question really for Dominic. You mentioned the various grounds 5 and the fact that the landlord has to serve a notice saying, I might seek possession on this ground. And it's an offence to seek possession if you haven't served the notice. But my reading of the bill is that they're mandatory grounds. So am I right in thinking the court has to make a possession order and the local authority can prosecute, which seems to me a little bit crazy, but that's my reading of the grounds. As you say, it's not a condition of the ground that they've served that notice, but it's an offence or it's attracts a penalty not to.
So there's always one question that you're desperately hoping nobody will ask, because it is right. Why didn't they put that provision in the grounds themselves? Why did they put it elsewhere? However, it is a breach of the landlord duty, and that is a specific. So you are doing something unlawful by not doing that, and not only that, it is a breach which has consequences, which suggests that not only is it unlawful, but it's really intended that you don't do this. We interpret housing acts purposively. And it would be astonishing to my mind, in the same way, for instance, that the courts have said that, you know, to discriminate against somebody by claiming possession or taking possession, to discriminate on against them, for instance, for sex or whatever, it is unlawful, and consequently the court cannot make a possession order in those circumstances. There's no provision out there that says, you know, there's nothing in the Housing Act that says if by taking this you are discriminating on the Equality Act, you cannot have possession. But the courts have said it's an unlawful act. The courts cannot justify an unlawful act. So I think that's my answer is it would be astonishing if the courts said that. But it is true that the way it's drafted, you sort of think, oh, surely they would have included something that said you cannot claim possession for this. There is that bit that there are certain breaches that result in you not being able to use the grounds. Unfortunately, not for this. But again, it seems to me that so even though there are specific provisions saying in these circumstances you cannot do it, I would be very surprised if the court suggested that you could use a ground without that notice having been served. But who knows?
The pre-grant notice that you were.
Yeah.
Mm.
Yeah. So the way Section 16D and D sort of marry is a bit odd. I would have preferred to see it in the grounds themselves, but there we go.
Because the written, by not doing it, it's not an offence, it's a financial penalty. So I'm wondering if they'll make a distinction in terms of, obviously, unlike discrimination, but then that.
So it is whether it, so the only way you can draw it in is by saying that to act in this way is a breach of the landlord's duty, and that is an unlawful act. You cannot rely on an unlawful act, or rather, if you are acting unlawfully in some way, you should not be able to claim possession. No idea what the answer is at the moment.
I'm excited to find out, to be honest.
There it goes. Case number one. Well, thank you very much, everybody, for coming. As I say, I hope you'll stay and join us for some refreshments outside. If I can ask you again to thank all of our speakers for what I thought were fascinating talks.